Heavenly Royo.
A Tulsa man convicted in the murder of 4 women in 2013 will learn his fate.
That made you decide to pull a gun and fire.
A teen girl remains behind bars on murder charges. With a smile on her face, Heavenly Arroyo was arraigned as an adult, accused of stabbing 68-year-old Ana Vasquez to death. Police say Vasquez was stabbed over 20 times inside a Johnson Street apartment last night. Since Arroyo is being tried as an adult, cameras were permitted in the courtroom, and during her appearance, she smiled and even said thank you to the judge. Her attorney mentioned that Arroyo didn't understand the situation's seriousness.
Heavenly Royo.
That's me.
Court documents reveal that a teenage girl is accused of stabbing 68-year-old Ana Vasquez, a woman from Fall River. The Bristol County District Attorney's Office identified the victim, and the accused killer is Heavenly Arroyo. According to her defense attorney, Arroyo had allegedly stayed at Vasquez's apartment for a few days.
As far as I know, there was no relationship. It was a friend situation.
Police say it was Heavenly Arroyo who initially informed a family member of Ana Vasquez that she had found Vasquez unresponsive on the bedroom floor. Arroyo later told police she saw a masked man running behind the complex. However, court documents presented a different story. According to the records, police obtained security footage from the apartment complex that linked Arroyo to potential evidence. This evidence included bloody items of clothing that police found in a dumpster. A next-door neighbor mentioned that she didn't hear anything during the incident, but saw police at the scene afterward.
My fiance went to go throw something in the trash over there, and there were cops over there, and they go, "No, you can't put anything in the trash over there."
Back in court, Heavenly Arroyo was held without bail. Her attorney expressed uncertainty about where she would be detained, although he believed Arroyo would likely be transported to a juvenile facility despite being charged as an adult. The Bristol County District Attorney's Office stated that the girl, who had been living in the victim's apartment, stabbed Ana Vasquez more than a dozen times. Throughout the day, friends of Ana Vasquez shared the same sentiment. She was a dedicated mother and grandmother, and a genuinely wonderful person.
No comments. Thank you.
Prosecutors revealed that Arroyo stabbed Vasquez upwards of 20 times. According to court documents, while in police custody, Arroyo reportedly said, "I killed the old lady, and I am sorry." Despite the gravity of the situation, when Arroyo appeared in court, she smiled and said thank you to the judge.
She knows she was in court. I don't believe she knew the seriousness of what was happening.
Court documents reveal that additional evidence later linked Heavenly Arroyo to the crime scene, including bloody clothing found in a dumpster.
I heard the news this morning. I saw the news in the internet and I couldn't believe.
A friend of Ana Vasquez spoke with us, though she preferred to remain anonymous and did not want to show her face. She shared that Vasquez was born in Puerto Rico, but had lived in Fall River for quite some time. According to the friend, the 68-year-old had 7 children and several grandchildren, and generally kept to herself.
Was very well loved from her grandchildren and everybody that met her that knew her.
Heavenly Arroyo was sentenced to 15 years in prison for the murder of 68-year-old Ana Vasquez. Tyrell Phillips, the suspect accused of gunning down one victim, which allegedly sparked a shooting spree that killed another man and left more than a dozen others injured, requested to be released on bond. However, the judge denied his request, stating that the best place for Phillips was in the Hillsborough County Jail. Phillips has been in jail for nearly a month and is now seeking release on bond, but prosecutors argue that he should remain in custody until his trial, calling him a danger to the community during a hearing this afternoon.
The defendant is guilty and will be found guilty ultimately, I believe, because he will not prevail on a self-defense claim because he's not preventing death, he's causing death.
Prosecutors say that dozens of surveillance videos from area businesses in Ybor City captured the shooting, which they described as brazen. The footage shows the incident unfolding in the early morning hours of October 29th on 7th Avenue in Ybor City, as many people were celebrating Halloween.
Did you ask the defendant specifically a question about what is it that you were in fear of that made you decide to pull a gun and fire?
Yes, he was asked that.
And in response, did the defendant say, "I don't know, there was multiple things"?
That's correct.
Did you ask him what those multiple things were?
Yes.
And did he reference the guy grabbing at his waist?
He did reference.
Phillips told police that the incident began after he waved to a girl he knew from school. He claims this led 3 young men to become aggressive towards him, with one even spitting on him. Phillips said he feared for his life when one of the men appeared to reach for his waistband, prompting him to fire his weapon. He claims he fired 3 times, fatally shooting the victim in the neck. After a lengthy hearing, the judge decided that the best place for Phillips was to remain in jail.
The safest place for him in our community is the inside of Hillsborough County Jail.
Tyrell Phillips was sentenced to life in prison for his involvement in the Ybor City shooting. He was convicted of multiple charges, including first-degree murder, following the shooting that resulted in 1 death and injuries to several others. A Tulsa man was convicted of murdering 4 women in 2013. A jury has recommended that James Poor serve life in prison without the possibility of parole for these crimes. The judge will decide whether to accept or modify this recommendation. Poor was convicted in March for the execution-style killings of 23-year-old Rebecca Powell, 23-year-old Coyote Melchor, and 55-year-old Julie Jackson. 33-year-old Misty Nunley. He was also convicted of 2 counts of robbery with a firearm. The murders took place inside an apartment at the Fairmont Terrace apartment complex near 61st and Peoria. James's brother, Cedric Poor, is charged with the same crimes and will be tried separately. James Poor was sentenced to life in prison without the possibility of parole for the murder of 4 women in 2013.
Tulsa man convicted in the murder of 4 women in 2013 will learn his fate.
Daniel, tonight, good morning. A jury recommended that James Poor serve life without the possibility of parole for those 4 murders in 2013. And today, a judge will have the opportunity to modify or accept that recommendation for life without parole. Poor convicted in March in the execution-style killings of 4 women, 23-year-old Rebecca Powell, 23-year-old Katie Melcher, 33-year-old Misty Nunley, and 55-year-old Julie Jackson. The jury also convicted him on 2 counts of robbery with a firearm. The killings happened inside an apartment at the Fairmont Terrace apartment complex near 61st and Peoria. Cedric Poor, James's brother, is also charged with 4 counts of first-degree murder and 2 counts of robbery with a firearm. He is being tried separately for these murders. His trial is set to begin on December 5th. James Poor is scheduled for that formal sentencing later today in the afternoon here at the Tulsa County Courthouse in Judge Kurt Glasgow's courtroom. We're bringing that update on KJRH.com and the 2 Works For You mobile app.
Jerry Cowser was sentenced for the 2017 killing of a man following a theft of 3 kilos of cocaine by a suspected illegal immigrant drug thief.
That on or about November 3rd of 2017, you did unlawfully, with malice aforethought, either express or implied, kill an unheld Vega by shooting him. He died as an approximate result. You're originally charged with indicted for murder. However, your lawyer and solicitor have negotiated a plea to voluntary manslaughter. How do you plead to voluntary manslaughter?
Shipments sent to him from California of major amounts of drugs. This particular day, he asked the defendant to pick drugs up for him, which is confirmed by a text message that Massey sent to Mr. Cowser that said, "Go to my grandma's house at 12 and wait on UPS man to deliver that box." He was careless in his handling of the drug package, and it was ultimately stolen by an acquaintance of his that he knew as Cuba. It became clear that if they did not recover the drugs immediately, they would face dire consequences. Massey sent Cowser back to 700 Will Jones Circle to find Cuba with the implied threat that if Cowser that Cowser needed to find Cuba, if he didn't, bad things would happen and we'd basically find him else. Cowser went back to 700 Will Jones Circle, demanded the whereabouts of Cuba, and when they could not provide that to him, they began to fire on them. He shot Angel Dominguez Vega and hit him with 1 shot to the chest. He shot repeatedly also at Hermino Mancia Cardenas, and fortunately did not strike him, but tried to, and he was able to run off into the woods nearby.
Cowser find himself in this situation. I don't want to say that he panicked, but what I do want to say is that with his schizophrenia, combined with the fact that Mr. Massey was freaking out, combined with the fact that he did know these victims and had come to them the first time asking for help finding Cuba, and he felt like that they would help him. And then when he went back, he found out that they were not telling him the truth, that Cuba had been there and gone, and that even though he had communicated with them in the past, they would take the position they couldn't speak English at this time. The frustration of that, with all these other stressors, it wasn't so much panic, Your Honor, I think it was more like when his brain was short-circuited. It's like a computer malfunction, too much stress.
He was sentenced to 25 years in prison. Preston Taylor was sentenced after reaching a plea deal with the prosecution. Taylor helped dispose of Sarah Stern's body, but cooperated with the police, providing details that led to solving the case.
He took Sarah's lifeless body, moved it not once, not twice, but 3 times, and dumped it into the Shark River. The pain and turmoil this case has had locally and nationally, overwhelming. Right and wrong, it was wrong. Evil, pure evil. No character, no words can be said to anybody that does anything like this to somebody's child.
As we know, prior to the sentencing, that Mr. Taylor lived with Leah McAtasney in Neptune City, in this small community where everyone, or for the most part, everyone knows each other. They clearly knew Sarah, knew Mr. Stern, knew the family. All these families know each other. This is really an unfortunate situation. This is the end of a long road for over 2 years for everyone involved. Clearly, Preston had the opportunity to stop this at many occasions. In the interest of justice, I'm going to post the following recommended sentence. And we will start with the count 2 robbery, first degree. I'm going to sentence Preston Taylor to 18 years in the Monmouth County, in the state prison, and that's subject to the No Early Release Act, meaning he will have to serve at least 15 years before becoming, I think it's 15 years and 15 years and 3 months approximately before becoming eligible for parole.
Preston Taylor was just sentenced to 18 years imprisonment for the counts that he was convicted of, to which he pleaded guilty. As was pointed out by the court, he cooperated with the state, a cooperation that the prosecution team, in particular myself, felt was necessary in order to be able to prove the case against the killer, in this case, Leah McAtasney.
I have one thing to say. Justice for Sarah, finally. It took a long time. It was difficult. The sleepless nights are the worst. I don't know if I'll ever get any rest, but at least this portion of the Sarah's murder is over, and we have justice for Sarah. It doesn't bring Sarah back. We want to keep her memory alive. We started some scholarship funds. We're going to continue to do that. We hope it'll grow. We want people in arts and media to be able to remember Sarah, and we want to be able to help them with that.
You'll go home after this, presumably. What will you do tonight?
I don't know, I may sleep.
For the first time?
First time in a long time.
Preston Taylor was sentenced to 18 years in prison for his involvement in the disposal of Sarah Stern's body. Samuel White pleaded guilty to involuntary manslaughter and child neglect in the death of his infant daughter, Jalea. White apologized for his actions in court, and Jalea's mother, Mandy Cole, told Judge Frank Addy that White was a good man and a great father.
Yeah, I would just like to say, me as the mother of Jaleea White and him as the father, he was an amazing dad, He's an amazing person. He's not as bad as you guys try to make him to seem out to be. He really isn't. Yes, he has a drinking problem. Yes, he needs counseling for it. I understand that. But he really, really is a great guy. And he would do nothing intentionally to our kids. Nothing. He loved her with all his heart. It was times that we'd be in the hospital when I had her, he would not leave her side. He'll leave me, but he won't leave her side. He was just a great guy. He really is. He's not a bad person. And I ask that you just give him a chance. Everybody deserves a chance. Just give him a chance, please.
apologize to Mandy. I want to apologize to my family. But I know apologizing ain't gonna bring my daughter back. You know, but I feel like me losing my daughter, that's more punishment than anybody can put on me. I mean, because the punishment being that the guilt won't always be there. And then just knowing that your daughter ain't gonna never come back. I could always have another daughter, but I can't never have another Jaleel. Never. And I just want to say that this is something real hurtful to go through, you know, to lose the child and to be going through this situation right here. It really do hurt. Because I just want to say I really am sorry. I really am remorseful. And the day that don't go by, I don't think about my daughter. I mean, I've been in here for 5 months, and the day that don't go by, I don't think about it. I mean, it's just something I have to deal with to the day I die. I wish it could have been me. My daughter had a whole life ahead of her. You know, I really am sorry.
Samuel White was sentenced to 20 years in prison for involuntary manslaughter and child neglect in the death of his infant daughter, Jalea. The teen accused of killing a man in the parking lot of a Columbus strip club nearly 3 years ago turned down a plea deal that would have allowed him to be free at a relatively young age. The deal would have granted him freedom before the age of 35. However, Raymond Richmond rejected the offer, firing his public defender in open court and opting not to accept the plea deal.
Richmond has indicated he wishes to fire me.
Police say the incident stemmed from a car theft operation gone wrong. 5 teenagers reportedly broke into cars in the Foxy Lady Lounge parking lot off Victory Drive. On June 5, 2020, London, an establishment patron, went to get into his vehicle and discovered Richmond inside. An altercation broke out between the two, and shortly after, Richmond allegedly shot London.
Your desire that you don't want Mr. Kraft to represent you anymore, is that correct?
He ain't been doing that for me, so I don't feel comfortable with him no more.
Public defender Steve Kraft, who has been representing Raymond Richmond for nearly 3 years, continued to support him even after being fired in open court.
I just feel like maybe it's a little overwhelming this morning, being in the courtroom and being faced with a life-altering decision with his other issues. He's confident that the doctors never disagreed about that, and the doctors are in agreement that he does have some intellectual disability.
The proposed plea deal, negotiated by public defender Steve Kraft and Christopher George, an attorney with the Prosecuting Attorneys Council of Georgia, reduced Raymond Richmond's felony murder charge to voluntary manslaughter. The offer on the table included a 20-year prison sentence for the manslaughter charge and 5 years of probation for the charge of entering an auto.
If he does not accept this offer, that the state has made clear they are withdrawing any future offers and will proceed to trial on the murder. The manslaughter is no longer on the table. I think that's an important understanding of that, correct, Mr. George?
That's correct, Judge. If the defendant, Mr. Richmond, does not want to accept the offer that his attorney fought for, from my understanding of the prior record before PAC was appointed the case, then we will revoke the offer and prepare for trial.
Under Georgia law, a murder conviction carries a mandatory life sentence. Teresa Chattahoochee Judicial Circuit District Attorney Stacey Jackson had to recuse his office from the case because he had briefly represented one of the co-defendants during a preliminary hearing when he was a criminal defense attorney. Despite the circumstances, Richmond did not waver in his decision to fire Kraft and informed Judge Martin that his family would hire a private attorney instead. For 25 years, Andrew Hatchet has been in prison, serving a life sentence for a murder he didn't commit.
God set me free.
Just before his 50th birthday, a judge overturned his wrongful conviction, and Andrew Hatchet walked free with a huge smile.
I just want to be with my family, go eat. That's it. He's a real fool.
In 1991, police accused Andrew Hatchet of killing a woman in a New York playground. The district attorney's office later deemed the evidence and the prosecution's star witness, who allegedly smoked crack that day, as flawed.
Police in this case did an incredibly sloppy investigation. He shouldn't spend another minute in jail for this wrongful conviction.
An organization called the Innocence Project conducted its investigation and uncovered crucial evidence proving that at the time of the murder, Andrew Hatchet was on crutches and in a cast, recovering from a gunshot wound he had sustained months earlier. This made it impossible for him to have used the force necessary to harm the victim. Prosecutors now face uncertainty about whether they will ever find the real killer.
Innocent for almost 25 years.
Despite being imprisoned all this time, Andrew Hatchet says he's not angry.
I feel good. I'm glad I'm free.
Now that he's back with his family, Andrew Hatchet is just in time to celebrate his milestone 50th birthday. On May 18, 2022, in Idaho Falls, an officer accidentally killed another during an altercation involving Jenna Holmes, a woman with a lengthy criminal record. When faced with her crimes, she showed no remorse and continued to blame others.
You're saying, I'm asking you to
I'm
say...
saying yes.
Okay, thank you. And were you able to see and hear the video explaining your rights to you?
Yes.
Do you have any questions at all about your rights in this matter?
No.
Right. I also have your application for an attorney. I reviewed that and I will appoint an attorney to represent you. It is the public defender's office that assigns public defenders, so that will be up to them what attorney they appoint, all right?
Okay.
And you're welcome to talk to them about that. You are here today because you've been charged in count 1 with a violation of Idaho Code section 18-4006 subsection 2, involuntary manslaughter. That carries with it a maximum penalty of 10 years in prison, a $10,000 fine, and a $5,000 compensatory fine. You've been charged in count 2 with a violation of Idaho Code section 18-905 subsection A, aggravated assault. That carries with it a maximum penalty of 5 years in prison and a $5,000 fine. You may also be required, you will be required upon conviction of the involuntary manslaughter to submit to a DNA test and a fingerprint. Fingerprinting. Do you have any questions for me, Ms. Holm, about what you've been charged with or the potential penalties?
The officer, is he getting charged with this as well, or just me?
I can't answer that question, Ms. Holm.
Come on.
That's a decision for the prosecutor's office. Bond in this matter has been set by Judge Riddock in the amount of $100,000. Your next hearing, Ms. Holm, will be a preliminary hearing on September 23rd at 1:30 in the afternoon.
Okay.
Do you have any questions for me, Ms. Holm, about anything that we've gone over here?
No.
All right, then you can be excused.
You know from the evidence, the testimony, and from that video, she's already been running. She's on the opposite side of the road, and you can see that from the video. She's not on the same side of the road that Dr. Maser is. She's running towards the other truck. She's charged, the foundation for manslaughter, the charge is assault against Deputy Maser. When she's coming down, you can see through Deputy Botcher's camera the extremely bright lights that Deputy Flagel has. The testimony is there's a special kind of dark out there. She's running, she gets down there, and as she's got the machete to her hand, she gets down there for less than a second. She raises it while the light's still in her eyes. She sees the car. As soon as she passes, it drops, and what does she say? I can't see. And she walks right by me here. Doesn't approach, she walks right by. Now, remember, Your Honor, they talk about meth. I wouldn't downplay how bad meth is. I'm not trying to here. But they want the court to focus on that to show that Jen's just a bad person. So let's blame her. Well, Judge, that's a factor, but Jen also considered a lot of mental health issues that were going on. She also, let's put both of those things aside. Consider her state of mind and her intent. She's a lone woman on a dark, remote highway who just had her car rolled. She does not have cell service. Are we really going to fault her if my wife in that situation, and there's a machete there, out on a highway where homeless people were just told to leave by Deputy Botcher? There's a lot of joggers and people around. I would say she gets that machete until she gets to safety. So they want to fault her for having a machete in her hand. And then as this progresses, it's windy, it's dark. She's hearing Deputy Botcher give her commands. I'm not saying he did anything appropriate at all in that. But she's hearing that with wind, with strange persons in front of her with a truck, who has a dog. He admits he trusts her with the dog. I understand as these commands from Botcher come, they come very quickly. Sometimes it's a sir, sometimes it's not. Go forward, keep moving, Jenna. Stop. This is Deputy Botcher. Keep moving. Go forward, sir. Not all the commands were there. There was wind blowing. We heard from the testimony. I got a transcript from Deputy Botcher. We heard from the testimony that it was very windy, and he thinks that she could hear him. But we can't be sure of that. And considering that, well, I'll try to point. In any event, Jeff, we heard Trooper Cox explain that people go through shock when they go to these events. There's an element of shock here for Jenna and for trauma. Coupled with whatever mental health, well, I know the event's already there. It's not my burden to show that wasn't the case. It's the state's burden to convince you a lower standard of evidence is probable cause. They don't have to prove beyond a reasonable doubt. But it's their burden to get to cause. You can't find manslaughter or source cause. It's their burden to show you that whatever that assault was, there was actually a threat made. I would argue, looking at the video, considering the evidence, less than 1 second, the immediately dropping it when she gets to the light. She's already had some strange car. She's been dealing with this dog. But she didn't have an intent to threaten. That was an offensive move, and she was already running that direction, but on the other side of the road. That is not, more likely than not, that she committed a crime. It's highly suspicious of that facts, but it's not probable cause. She didn't commit an assault. Very quickly, last thing. One thing that has not been answered here with respect to Dr. Flegel, when should anybody, let alone an officer, drive through blinding lights? And then when should they do it at 91 miles an hour? Please look at the video, Your Honor. On Deputy Botcher's video at 5:50, you can see how fast Flegel's car was moving. Likewise, Judge, if you look at 5:29:05 of the exhibit, he's going 91. If you look at the video on Flegel's dash cam, at 5:29:10, there's no change. At 5:29:11, light brakes are applied. 10 seconds later is when Maser is killed. So 10 seconds, he chooses to drive the blinding lights, starting at 91. He's still above the speed limit at impact. The car in front of him came to a complete stop.
Dear Jenna, I sit here writing this letter with the greatest hole in my heart and soul that a mother could ever have. The choices you made May 18th, 2020 resulted in the death of my beautiful son, Wyatt Maser. You have destroyed our family and taken the most caring, selfless soul this world ever knew. His daughter will never know her father. She will never get to go to father-daughter dances, have him teach her to ride a bike or to drive. She will not have him to walk her down the aisle at her wedding. She was just 8 months old when he died. She does not have any of her own memories of her father. All she will ever have is the photos, videos, and stories of others. She has been robbed of a father by you and by your choices. His wife lost her husband and best friend, her one true partner, the person she could lean on the most. She became a widow and a single mother because of you and your choices that night. I watched her struggle and fight to figure out how to live without Wyatt. She does not get to grow old with Wyatt, have more children with Wyatt, or watch grandchildren with Wyatt. Again, because of you and your choices. As for me, your choices took my son, half my heart and soul. You have robbed me from watching my son be the incredible father he was. I do not get to see him play with his daughter. I have to try to explain to a 3-year-old that her father is in heaven instead of here on earth where he should be, all because of you and your choices. I am appalled that you have not taken one bit of responsibility for his death. Your actions caused this whole event to happen. All you have done is worried about you and what you can get for yourself. Never once have you asked about our family and how we are coping. Never once have you said you were sorry for the choices you made that night. I know your child passed away, and for that I am truly sorry. But at least you got to be with him in his last minutes to say goodbye. Our family was not afforded a goodbye because of you and your choices. For the last 2.5 years, I have tried to learn to live without my child, and I still have no idea how. I do blame you for his death because you are responsible. I refuse to hate you because I will not let you have that power over me. I have, however, will never forgive you for what you have done. I do not want to hear about your addiction or your mental health problems because you have choices. You have a choice to treat both of them and do the right thing, but you have always chosen to do wrong. You have my family with what you have done, and I do not believe that you were sentenced to what you deserve to be sentenced to today. You get out of jail and get to leave this community, but I hope for what you have done, Wyatt's face crosses your mind every day. I hope every one of those thoughts is painful and reminds you, Jenna Holmes, you are responsible for the of Deputy Wyatt Maser.
On me and my family. From the first call that morning that Wyatt had been in an accident to the heartbreaking call that his wife Paige was forced to make to tell me that my beautiful son was no longer with us. At the time, we did not know what had taken place, just that now and forever we would all be forced to go on living with a gigantic hole in our lives. That all the plans, hopes, and dreams that Wyatt and Paige had for their lives were no more. That as a month old, his pride and joy would never know her daddy. That we, as parents, would never again hear him say, "I love you." We don't get to watch him be a father, a husband, or a brother. We don't get to pick up the phone and talk. We just have his memory. As we miss him every day, every holiday. Wyatt was truly one of a kind. He always wanted to help, and he always wanted to do the right thing. He was proud of what he was doing, and he was doing it for the right reasons. It was to help people. There was proof of that in how he handled himself and the self-control he showed that early morning hours. And that is the reason that you, Jenna, are alive. It was because he did have that, and he was doing it for the right reasons. He recognized who you were and the issues you had. You were the catalyst to his death, though, because of your decisions. Your addictions, they put him in that place at that time because you have refused to change yourself your entire life. You have no idea what your actions have caused this family, and you have taken zero responsibility for your actions, and it is heartbreaking. You and your attorneys have this out for over 2 years. That has just caused more pain and frustration for everyone in our family, and you show no remorse. Even when you were bailed out of jail, you showed no remorse as you went back to using drugs again instead of changing your life for the better, of getting the help that you need. And I truly pray that you and your actions do not hurt anyone else. Wyatt had a belief that officers of the law should be held to a higher standard. He said that if I'm going to uphold the law, I need to follow it. I just hope that someday Sergeant Randy Flegel would be held to account for his part in Wyatt's as well. I have no idea why this has not been done. If Wyatt were a civilian, would he be held to account? If it was a civilian that hit him, would they have been held to account? All questions that no one seems to want to answer, and I don't know why. Why are you out living your life with no consequences for your negligent actions when we have to live every day with the pain of losing Wyatt? You will never understand how we feel. We haven't even heard, and I'm sorry. But I pray that God gives this family strength to continue through life without Wyatt the best way we can. And I pray that God gives all of you strength to choose to do the right thing, even though it will be hard. And I pray the name that Wyatt Christopher Maser is forever remembered by all. Thank you.
This is a moment where it will not restore the things that were lost. And from various individuals we've heard today suggesting that there is perhaps no real closure, at least this proceeding, I hope gives an opportunity for all of those affected to at least close a chapter in all of this. In the description, it was the worst day of so very many people's lives. And that's apparent as we listen to one another today discuss how this has impacted each of you. So, in a typical sentence, the court looks at the mitigating facts of a case and the aggravating facts. The court exercises discretion. Counsel certainly knows that there are 4 objectives of criminal punishment. I'm going to state them, even though, as I said, my discretion is limited on this resolution, but it's important to consider what are those objectives: protection of society, deterrence to you and to others, rehabilitation, and punishment. And while they weren't framed in those objectives in argument, I think everyone understands that they're all principles that are relevant to today's resolution. And I know the parties have strived for that in this agreement. It's very clear to the court that in each of your analyses, it really amounts to elements of offenses, and counsel uses technical terms. There were descriptions today and over the course of the legal proceedings that use terms such as proximate cause, legal cause, intervening causes and acts. And I think it's clear that everyone agrees that this was an event that should not have happened, and it did. And we are here today to confront that and to, in your case and in the state's, offer a resolution and for you to walk through those doors and accept it. My role in this case is to sentence you consistent with the amended charges, and I will do that, and I will do it in a way that is the maximum. And as I stated earlier in the proceedings, it is up to and will be the 6 months for the exhibition of a 1-year sentence for the resisting and obstructing. It is still appropriate, even though there might be different methods of accountability and collection, to impose a fine. I will do that on each of the 2 misdemeanor offenses, the $500 and the $1,000. As requested, the court will run these 2 offenses concurrently, and under the law, you are entitled to that custody that you have experienced while this case has been pending. I will turn back to defense counsel with your familiarity of reimbursement for the services of the public defender on these types of matters in magistrate court. If you have any comments, Mr. Crane.
Is the court asking what's commonly? I would venture to say that if they do impose it, it's as low as 50, as high as 100 150, usually in magistrate court.
Okay.
It's not a great amount that they impose.
And it's, I know these things are not lost on the parties in all respects with regards to the resolution that has been arrived at. As I said earlier, I know the parties have invested a significant amount of time and effort, and so there really is no amount, I think, that could be ordered to reimbursement. And so I think the court understands that, the nature of the agreement, and in the magistrate arena, there won't be that. That will be just simply the public defender's budget expense. Ms. Holmes, do you have any questions regarding the sentence? Any from counsel?
No.
Court costs and victim relief.
Court costs are standard based upon statute for these two offenses, and victims relief fund applies in a different amount, not to the felony, but misdemeanor. Counsel, do you have an understanding?
I usually just see the court costs.
That's, I think, my familiarity with misdemeanors as well. Subject to those pronouncements, any other questions?
And Your Honor, I believe that the court has to declare that the amount of times they're credited, and so it sounds like for a concurrent 1 year would be sufficient. I don't know if the court was misunderstanding our recommendation, which was consecutive, but we did ask for consecutive.
I heard concurrent. So let's talk about that. Let me just confer with counsel. You may.
Pre-judgment incarceration can't be ordered consecutive. You have to get concurrent credit for any pre-conviction time. And then if there's any time left over, the court can impose that consecutively, so that the court's discretion is limited there as well.
Right.
All right, very much.
And I heard the word concurrent.
This case revolves around Dr. William Husel. From February 2015 to November 2018, at Mount Carmel St. Anne's Hospital in Columbus, Ohio, Dr. Usel was accused of taking the lives of terminally ill patients. Once the police identified Dr. Usel as the suspect behind these horrifying acts, they decided to file charges against him. The defense's job is to prove the accused's innocence, and the defense attorney in Dr. Husel's case made a strong effort.
Good morning, ladies and gentlemen.
Good morning.
Have you ever thought of it? You're in a hospital. Your body's ravaged by disease. Who do you want there beside you in these final precious moments? How do you want them to see you? How will you handle the fear that is right there? The anxiety. As your body starts to break down and you gasp for air, and the pain of the disease that you're suffering from overcomes you. What do you concentrate on? Pain? Trying to breathe? The fluid in your lungs begins to rattle. There have been bad deaths, and that's the phrase you can all be familiar with by the end of this trial. Sometimes foam comes up in your mouth, cough up. Dying is a terrible, terrible ugly thing. In this case, I am certain for both sides, has created a terrible feeling within us because we have to face it. And it's absolutely something we never want to talk about, think about, or really look into. But there's one thing for certain. We will all experience it one day. Each and every one of us. That's the only certainty. So this case, ladies and gentlemen, is about 100% comfort care. A person's right to live their final moments in peace and dignity. No one is better to determine that than the individuals who are at your side in those final moments. This case covers a wide range of dedicated healthcare professionals, ranging from doctors, nurses, and pharmacists, as well as chaplains, other spiritual advisors. And the one thing that you all need to realize that in order for you to recognize that if this is a murder case, that all of these people were either involved in a conspiracy to commit either were conned by some suave doctor, or are perhaps the dumbest people that ever walked the face of this earth. Each and every one of these patients were not just seen by Dr. Wyatt Maser. And each and every one of these patients had multiple healthcare professionals in and around their care. And today I'm going to cover with you quite a bit of extensive information where you will hear things never before disclosed. You will be the new experts as to what exactly happened in this case. So my opening statement will be quite a bit longer than my colleague. And that's because what I want to do is I want to set you up in a framework of how you're going to view this evidence and what to look for and how it all connects. It's a complex case, and my job is to try and make it a little simpler and easier to understand so you can actually apply the law to it. And one of the things that you're going to recognize right off the bat is there's no such thing as a medical murder case, and that this is not a murder case, and it's far from it. William Husel was exercising compassion to his patients and tried to free them from pain and let their last moments on earth be ones of peace. Because that's what his patients would have wanted, and that's exactly what his patient's family wanted, even when they begged him to make sure that they were comfortable. Now, what I'm going to cover with you is first an outline of how we got here. And that's because it's really important if you think about it. Everybody wants to know, how in the world did this all happen? How did we get here? And you're going to recognize the series of events that took place that are downright shocking. And there are going to be moments where I'm going to tell you, please take note of this. Because that's what I want you to look for as this case progresses. And after I tell you how we got here, I'm going to cover with you some of the issues with the law that this case simply cannot overcome. And I don't mean it as a technicality. I mean it as you'll see that because it's not a murder case, This case doesn't belong in this forum. There can be all types of criticism of these people, because I include them, including William Husel. There can be all types of criticism, but there will not be any evidence of a criminal act. To the contrary, you recall my colleague mentioning what this case is not about. Well, that's not what they want you to think about, and you're going to shortly see why. So, let me tell you first about who Dr. William Usel is. William is married to Mariah, a nurse we met at Mount Carmel, and they have two lovely, beautiful daughters. And I can assure you that they are what this case is ultimately about for William. William Usel is a local Ohio boy. Born and raised in Cleveland. His father worked in mass transit. His mother was a stay-at-home mom. Comes from a very blue-collar family. But as you can see, after graduating from Ohio State, he took a series of educational degrees, which included performing medical research at Case Western University, graduating from medical school at Ohio University. He completed a residency of 4 years at the Cleveland Clinic, a very prestigious place where the best of the best are trained. Subsequent to that, he completed a critical care fellowship at the Cleveland Clinic that lasted a year. And his very first job was at Mount Carmel. If you look at this and add it up, it is a series of 17 years of higher education. And the state of Ohio wants to convince you that despite the 17 years of trying to be a doctor, that he decided to end people's lives so that they live in 5 minutes as opposed to 10 minutes. I'll tell you right off the bat, we dispute that these patients were not terminally ill, and you're going to see that clearly. In fact, it's always been everyone's position that these were terminally ill patients until much later. So, how did we all get here? I think a good starting point is right here. These are all of the palliative withdrawals that we were able to get from Mount Carmel's hospital. And it covers a list from 2014 all the way to the very last one, which occurred November 20th, 2018.
Relative to count one, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count one of the indictment for murder and not guilty to any lesser offense. Signed by each and every juror. This is the 20th day of April, 2022, and it has the 12 signature lines there with the 4-person designation. Relative to count two, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 2 of the indictment for murder and not guilty as to any lesser offense. Signed by each and every juror. This is the 20th day of April, 2022. There are 12 people's signatures there with a 4-person designation. Relative to count 3, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 3 of the indictment for murder and not guilty of any lesser included offense. Signed by each and every juror. This is the 20th day of April, 2022, with the 12 signature lines. Relative to count 4, We, the jury in this case, find the defendant not guilty as to count 4 of the indictment for murder and not guilty of any lesser included offense, signed by each and every juror this the 20th day of April, 2022, with the 12 signatures found there with its 4-person designation. Count 5, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 5 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror this the 20th day of April, 2022, and it has the 12 signatures present on the document and the 4-person designation. Relative to count 6, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 6 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror this the 20th day of April, 2022. It has the 12 signature lines with the 4-person designation. Relative to count 7, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 7 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror this the 20th day of April, 2022. 12 signature lines are present and signed with the 4-person designation. Relative to count 8, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 8 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror this the 20th day of April, 2022, with the 12 signature lines with the 4-person designation. As to count 9, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 9 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror this the 20th day of April, 2022, with 12 signature lines and the 4-person designation. Relative to count 10, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 10 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror this the 20th day of April, 2022. 12 signature lines are present, and the 4-person designation is present also. Relative to count 11, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 11 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror. This is the 20th day of April, 2022. The 12 signatures are present, along with the 4-person designation. Relative to count 12, we, the jury, in this case, being duly impaneled and sworn, find the defendant not guilty as to count 12 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror. This is the 20th day of April, 2022. 12 signatures are present with the 4-person designation. Relative to count 13, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 13 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror. This is the 20th day of April, 2022. 12 signatures are present, along with the 4-person designation. Count 14, we, the jury in this case, being duly impaneled and sworn, find the defendant not guilty as to count 14 of the indictment for murder and not guilty of any lesser offenses, signed by each and every juror. This is the 20th day of April, 2022. 12 signature lines are present with the 4-person designation. Juror Foreman, is this the verdict of the jury?
Yes, it is, Your Honor.
Okay. Mr. Zion, do you want to poll?
I do not, Your Honor.
Poll?
No, thank you.
Okay. I want to thank you for your service. We've got some paperwork to discharge you on. I did get an answer to the mystery text yesterday. I'll explain that to you here in a couple minutes. I want to thank you for your service. You are now discharged.
All rise.
Thank you all.
Y'all may be seated. For the record, I have the other forms. They're all blank at this point in time. Dr. Usel, you're now discharged from any conditions of the court. I ask that you kindly check in with pretrial on your way out to make sure that there's no problems or if there's anything that they need to clear up. Okay, but you are now discharged. Okay? Anything else to come before the court?
Not from the state, Your Honor. Thank you.
No, Your Honor, thank you.
Okay, I'm gonna go back and talk to them for a minute. Do you guys want an opportunity to talk to them?
I have no reason to unless they wish to speak to us, Judge.
Okay,
I would, Your Honor.
okay. I'll see. I always leave it up to them.
I understand.
Okay, with that, we stand in recess.
Thank you, Your Honor.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.